Good morning. Welcome to Employment Hour in 30, the show where you can discover your workplace rights and how to defend them. I'm Ryan Bonner, guest host in for John Scholes, joined by Lior Samfiru, employment lawyer with Samfiru Tumarkin law firm. And we have a great show for you today. We'll talk about the 10 commandments of termination of employment and why you need to know them. We'll talk about severancepaycalculator.com, a website you should have, an app you should have too, before, during, and after termination. And we'll get to some other questions that come into the firm regularly through email, help@employmenthour.com, and also that come in through terminationquestions.com and through our weekly radio shows that we have, the Employment Hour. We'll get to all of that and more. But first, we start every show off with the week that was. Lior, what happened this week?
Well, Ryan, thank you. Great to be here with you and getting another opportunity to educate and inform our viewers about employment law and workplace rights. I get great feedback. I'm so happy about that. People call me at the office, email me that they saw the show and they learned something about their rights, that they feel better and more empowered. And that's really what this is all about, to give you that power that you know you have rights. The fact that the law is going to help you if you have problems in the workplace. Maybe your boss is mistreating you, maybe you lost your job, maybe your hours of work have changed. So you need to know what to do in all of those situations. That's why we're here every week, to inform you about those things. So let's start off, John, I called you John. I call you Ryan, though. You go by John sometimes.
Yeah, sure.
Talk about something that came across my desk just a few days ago. Now, we've talked on the show before, Ryan, about harassment in the workplace and an employer's obligation to protect employees from harassment. But it doesn't just apply to things that happen at work. An employer also may have an obligation to protect an employee and to try to prevent harassment that happens between employees outside of work. So in this particular situation, I got contacted by a young lady who worked for a company, had never had any issues, but one of her coworkers, I guess, decided that he may have had some feelings for her, and off work would call her, would send her emails, I'm thinking of you, could you come over? And this went on, and she was very direct, said, not interested, appreciate it.
Shut it down.
Shut it down. But not only did he not stop, it actually got worse. Oh, no. So he became more direct and sexually explicit. And it got to the point, and again, by the way, Ryan, this happened off work hours. Nothing ever happened at work.
Yeah.
No, even though they worked together, nothing happened at work. Well, she went to her boss and said, I'm uncomfortable. I have to work with this person, and off work he's harassing me, he's bothering me. Well, the company, the boss said, well, because this is not happening at work, that's not our problem. It's something that happens on your personal time, so you have to deal with it. It has nothing to do with us. And keep in mind, she still had to work with this person. So she called me and she said, I'm very uncomfortable going into work now. I see this person all the time. I know that when I get off work or on the weekend, I'm going to get text messages and calls from him. My boss won't help me. What do I do? So Ryan, the first thing we need to understand is that an employer cannot ignore any incidents between employees that happen outside of the workplace, because it does get translated into the workplace.
Especially in this day and age. Everybody has Facebook, social media, text messages, email. It's
Absolutely.
easy to stay connected outside of work.
And if you're going to work with someone that's otherwise harassing you, it's going to impact your work environment. It's going to create a poison or toxic work environment. It's going to make it very difficult to work. And the company has to avoid that, has to protect employees from that. So the company can't simply draw a line in the sand and says, this is work, that's outside of the work, and if it's outside of the work, it doesn't bother us. If it happens between employees, and if it could translate into the workplace, the company has to do something about it. And if they don't, the employee, in this case, this young lady, may be able to treat her employment as being constructively dismissed. She may be able to say, because you're not protecting me, because you're not helping me, I may be able to leave with my full severance. This also could be a human rights issue. So I'm working with this young lady right now to try to get her what she's owed. But I want the lesson there to be very clear to employees and employers. You cannot ignore conduct that happens outside of the workplace. If it can or could translate into the workplace, the company has to do something about it. The protections that an employer has to give to an employee could extend to off-work conduct as well.
If you're in a situation like that, the number to call Lior at is 1-855-821-5900, or email him help@employmenthour.com. And as always, you can go to employmenthourtv.ca for more information. Now, Lior, you also do radio shows throughout the week, every week, the Employment Hour, and you take a number of calls. People call in live and ask you for your advice, for your input on their particular employment law cases. We're going to get to one of those calls right now.
if you're working at a company 7 years and they hire you as a consultant, right? But here's the difference. They treat you like an employee. So you clock in, you clock out, you get a lunch hour, you get the employee handbook of all the rules and the etiquette, everything else that goes with it. But yet, they still want you to declare yourself a consultant. How long can a company do that for?
The classic, are you an employee, a contractor, what are you?
Yeah, probably one of the most common calls or questions that I get, Ryan, is about people that are misclassified as contractors when they're really employees. So let's break this down a bit. If you're working and you have a job and you work for the company and you're treated like an employee, then you're an employee. It doesn't matter what you call yourself or what the company calls you. So many people are misclassified where they believe they're independent contractors, and that's wrong. And that's important because if you really are an employee in the eyes of the law, you have rights as an employee. Now, the question here, this particular person clearly is being misclassified. They're an employee. But the question is, well, how long can the company do this for? Well, they can't do this at all. The moment they do this, on moment one, it's illegal.
Really?
They cannot do that. But what the real question is, what are you going to do about it? What are your options? What are your recourse? Now, if you want the company to stop treating you as an independent contractor, well, you can potentially go to the Ministry of Labor and say, Ministry of Labor, they're misclassifying me. I want you to order the company to treat me as an employee. That's something you can do. The problem with that is it's going to create conflict with the company.
The employer might not like that.
They might not like that. And if you're going to continue working, that's a problem. Another way to deal with this is to deal with this when employment is terminated. So if you're, quote unquote, a contractor, but you're not really a contractor, if they let you go, at that point you can deal with it by getting the severance that you're owed. So that way there's no conflict right now. And when the company lets you go, they may say, we're not going to pay you severance because you're not an employee. But guess what? Because you are, they're going to have to. So either deal with it right now, go to the Ministry of Labor, or deal with it when you lose that job. Give me a call, and I can help get you everything that you're owed.
So if you are a contractor, an independent contractor, it's important to give you a call and just find out where you stand. Just don't assume that, oh, no, I'm not an employee. I know for sure I'm not. Find out, of course, first.
Yeah, I always talk about the plumber example.
Yeah.
If you're a plumber and you're going from house to house fixing people's plumbing problems, and tomorrow you're going to go to different houses, do the same thing, well, that plumber is an independent contractor. He's in business for him or herself. But if you go to work somewhere and you have a job and they tell you what to do, and then you go home and you come back, do the same thing the next morning, you're an employee. It doesn't matter what you call yourself. It's simple, Ryan. It's substance over form. All right? If you look like an employee and act like an employee, you're an employee, even if you call yourself a contractor. It doesn't matter what you've signed. It doesn't matter how you're taxed. It doesn't even matter if you have your own company. If you look like an employee and act like an employee, you're an employee.
1-855-821-5900, the number to call Lior at today, or help@employmenthour.com. There's a website you should also check out. It's terminationquestions.com, where you can leave a question anonymously, and a lawyer at Samfiru Tumarkin will answer your question for you, and we're going to get to one of those right now. I posted a comment on my Facebook mentioning I was having a bad week at work and hopefully the next one would be better. Nothing about where I work. Today at work, they asked me about that comment and then fired me on the spot. I worked for the company for 4.5 years. I'm pretty sure this is wrongful dismissal and I should get my job back. At the very least, I get 2 weeks' pay, right?
There's a lot there, yeah. A lot to digest there and a lot to go through. So let's start with the Facebook postings. So certainly, if you're embarrassing your employer, and by the way, that doesn't sound like that's what happened here, but even if she was embarrassing her employer, that's not a good thing, but that does not mean that's cause. Remember, to let someone go for cause is the ultimate penalty. You would have really had to do something awful. Now, in a situation where you're not actually identifying your employer, even if some people may know, it's certainly not cause. The employer can ask you legitimately to take it down, but beyond that, they probably can't make you, and they certainly can't let you go for cause. It would have to be pretty bad, pretty nasty for you to be fired for cause without compensation, without severance, because of a Facebook posting. But beyond that, the question is this a wrongful dismissal? It is absolutely a wrongful dismissal if you're let go without compensation. Now, in terms of getting the job back,
is that possible?
In 99.99% of cases, it's not possible. The law in most cases doesn't know how to make companies take you back. The law just knows how to compensate you by way of dollars and cents, severance, in other words. So no, there's no real way to make the company take you back, but what there is a way to do, what the law does, is make them pay you severance. And here's where the 2 weeks comes in. It's not 2 weeks. Now, let's see what that actually is.
Let's do it. Let's run it through the severance.
Let's run it through the severance calculator. We'll talk about it more in a second, but what I did is I took that information from that email and I put that through the severance calculator. So if we're talking a position, let's say it's just a technical position, 4.5 years of service, I picked an age, 42, and how much severance would someone like that get? Well, the severance calculator correctly identifies as it being 8 months' pay.
A far cry from the 2 weeks.
A far cry. So this person thought, well, they owe me 2 weeks. I'm upset that they didn't give me 2 weeks' pay. Well, no, they don't owe you 2 weeks. They owe you 8 months' pay. And that's why the severance calculator is important. We'll talk about it more. And that's why that's why we're here, to inform people and try to bust some of those myths that people believe in terms of, oh, it's 2 weeks' pay or it's a week's pay per year of service. So the lessons here, it's difficult to terminate for cause, many cases almost impossible. You can't necessarily get your job back, but guess what? The severance that you're owed is going to be a lot more than you realize.
SeverancePayCalculator.com is the website, and as Lior said, we will talk more about that in depth in a bit, but you can always call Lior 1-855-821-5900 or help@employmenthour.com. Let's get to the main topic of the show here, Lior, and it's the 10 commandments of termination of employment. You've taken the tablets, hiked up to the mountainside, and held them over your head, and here's what these tablets proclaim.
Let's do it.
Number 1, thou shalt think about termination when accepting a new job.
The 10 commandments, let's start off with thou shalt think of a termination when you accept a job. The reason for that is when you accept a job, usually you're going to have to sign a job offer letter or an employment contract. And what some companies are going to do is they're going to stipulate in that contract what they would have to pay you if at some point down the road you lose your job. And oftentimes, most times, when the company does that, they try to limit your entitlements. So you may accept a job that at some point is going to cost you tens of thousands of dollars in severance. But if you're aware of that, if you think of that issue when you accept the job, you can identify that and try to negotiate that out. And if you're not sure if it's there, if you're not sure how to negotiate that, give me a call. I'll help you. But you have to think about termination of employment when you accept the job, because guess what? Your employer is thinking about it. And if you don't, you're going to find out a year, 2 years, 10 years down the road that now instead of getting $100,000 worth of severance, you're getting $5,000 worth of severance. A horrible mistake to make. So think about it when you accept the job.
And many people may think, oh, my employer's a good guy or good girl. You know, I've spoken with them. Everything's on the level, but hidden in that contract, you never know what could be lurking there.
It is very common, and that's just one of the things you got to be mindful of when you accept a job. But definitely think of what am I going to be owed when I lose my job when you first accept the job.
10 commandments of termination of employment. Number 2, thou shalt not accept a temporary layoff.
A temporary layoff is a situation where a company essentially says, we don't have enough work for you, so we're going to send you home temporarily with the idea that at some point, hopefully, we can bring you back. The problem with that is twofold. Number one is a company actually doesn't have a right to do it. So if the company lays you off temporarily, you may be able to treat that as a termination right away and get your severance. There's no right to do it. The other problem is, despite what I just said, if you let the company do that, if you say, okay, I'll sit at home and I'll come back when you call me 3 months down the road, by doing that, you're giving them the right to do it again and again and again. So you may come back and then be laid off again and then be laid off again. And at that point, you can't do anything about it because you let them do it the first time. So you gotta be very careful with layoffs. It could essentially spell the end of your employment, and if you don't deal with it appropriately, you're gonna end up losing a lot of compensation that's otherwise owed to you.
And there are a lot of people who will come to you and say, well, I work in an industry where temporary layoffs are just part of the game and they are quite legal, but, you know, truth be told, that's not the case.
In some industry, maybe. So let's say if you're a roofer and there's no roofing being done in the winter, let's say, then it's assumed that you could be laid off temporarily. But it would have to be pretty darn clear that that industry never operates in a time of year. Most industries, that's not the case, and there's no such thing as an assumed, in most cases, temporary layoff. And if your employer is going to start, I call it messing with the terms of your employment, you're better off rejecting it, getting your severance, and moving on. 1-855-821-5900 or help@employmenthour.com. Number 3, the 10 commandments of termination of employment. Thou shalt respond to any negative reviews or discipline. Very, very important. If you're being disciplined or you got a negative performance review and you don't agree with it, you have to say so. Silence is the same as saying, I agree. It's the same as accepting. And the problem with accepting, and later, if they want to let you go because of that negative performance review, it's going to be very difficult to say, oh, that performance review was not legitimate because you accepted it. So if your employer is going to give you discipline, if your employer is going to give you a bad performance review, usually what the employer is doing is it's building a case against you to potentially let you go. So don't just sit there and accept it if you don't agree with it. Say so. Say you don't agree, say why. Give your version of events. Don't make it easier for the company to let you go.
This one, number 4 for the 10 Commandments of Termination of Employment. It's pretty self-explanatory, Lior, but thou shalt not commit serious workplace misconduct.
It goes without saying, or does it? Certainly, the best way not to lose your job is not to commit workplace misconduct. So be reasonable. None of us are perfect, of course, and we're going to make mistakes, but that's not what I'm talking about. If you know something is unacceptable, don't do it. If you don't do it and you commit the normal small mistake that most of us do, then you're not going to be able to lose your job for cause. Very important advice.
Number 5, 10 Commandments of Termination of Employment. Something you may not be doing is thou shalt always keep copies of all relevant documents.
Yeah, I never like a situation where someone says, oh, I think there's some document that says this or says that. If there's an important document, I mean an employment agreement, very important, a disciplinary letter, a policy, a pay raise letter, you want to have a copy of that because at some point you may need it. At some point we may need to look at it if you lose your job or if there's a potential constructive dismissal. So have a file, call it my workplace documents file. Keep everything relevant to do with workplace there because at some point you're going to need it. And at some point the fact that you've kept that could mean the difference between getting a lot of money in severance and getting very little.
And when you do need that file, you can call Lior at 1-855-821-5900 or email him help@employmenthour.com. You can also go to employmenthourtv.ca. In a moment, we'll cover off the rest of the 10 Commandments of Termination of Employment. And in a moment, we'll get to the severancepaycalculator.com right here on Employment Hour in 30.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com.
Welcome back to the Employment Hour in 30. Ryan Bonner with you, as is employment lawyer Lior Samfiru from the Samfiru Tumarkin law firm. 1-855-821-5900 is the number to call him at, and help@employmenthour.com and employmenthourtv.ca. Another website, probably the most important of the websites to remember, is severancepaycalculator.com. Lior, what is it?
Severancepaycalculator.com, a website that I created 4 or 5 years ago now to help people understand how much they're owed if they lost their job. People used to have to call me and, if it's the weekend, I'm sorry, I'm going to be home. I'm probably not going to be picking up the phone. Well, I just lost my job. I want to know. I'm going to stress out all weekend long if I don't know. So you go to severancepaycalculator.com. Anyone can go there. It's free. It's anonymous. You answer 3 simple questions: your age, position, and length of employment. And that's it. You're done. You're going to find out exactly how much you're owed, whether it's 2-month severance, 24-month severance, or anything in between. It's free, and it's so easy to use that it takes seconds. Now, the reason why it's so important is there's all these misconceptions. People believe I get a week's pay per year of service. Wrong, wrong, wrong. If you think you know how much you're owed if you lost your job, try it right now. Humor yourself, humor me. Go to severancepaycalculator.com. Try it. You'll be surprised. And of course, if you know someone that lost their job, you're talking across the street with your friend that is very upset because they lost their job, tell them to go to severancepaycalculator.com. Be a good friend. Trust me, they'll value it. Always the first place you go to if you lost your job.
Well, let's run through a quick example to give people an idea of what severancepaycalculator.com can do. I was recently let go by my employer in the software business after 10 years. I was told it was due to a lack of sales, even though they just hired 3 new employees. I have a clean record and even took a 15% pay cut to $59,000 a year ago to help the team. Can they legally do this? And what do they owe me? 1 week per year worked?
Yeah, well, that's exactly the types of questions that I get. Oh, I guess I just get the 1 week per year. Some people think, hey, it's 2 weeks per year. It's not that. It's based on the 3 factors, Ryan, which is age, position, and length of employment. The longer you work, the older you are, the more senior a position, the more you're owed. So let's use this example that you just read. Let's put that in our handy-dandy severance pay calculator. And so I'm going to use a salesperson as an example. 10 years of service, age of 52, $59,000 of salary. Guess what? Someone like that gets 12 to 14 months pay.
Wow.
So there goes your week per year, 12 or 2 weeks per year. And by the way, Ryan, if this person was, say, 62 instead of 52, that would have been higher. If they were, a more senior position, a sales manager, that would have been higher still. That's why it's so important to go to severancepaycalculator.com to find out how much you're owed. So this person let go without compensation. They're owed as much as 14 months' pay. That's a huge amount.
It is. And we have a huge television show here, Employment Hour in 30. We also are on the radio a couple times a week throughout Ontario. And it's the Employment Hour where we take calls live and answer people's questions about employment law. Let's get to another one of those calls right now.
It's a construction company. The owner is kind of retiring, and there's nobody to take over the business. We've all kind of know that when the projects we've got going are done, that's probably the end of the employment with them. And I know there's some unique rules in around construction, whether like employment standards or something. I'm just wondering if there's anything that we might be entitled to.
Great question.
Excellent question, and an important question, and one that I get often. There's misconceptions. We talked about that a few times. One of the big ones is people believe that in the construction industry, it's the Wild West. People believe that if you're working in construction, you don't have the same rights, certainly as relates to severance, if you lost your job. So let's clarify that. Your minimum entitlements may be different if you're in the construction industry, but forget about that. We don't care. Your full entitlements are the same if you're in construction or in any other business. That means if you lost your job and you're in construction, you still get your severance, just like we were saying before, based on your age, your position, and the length of your employment. You can still go to severancepaycalculator.com. I've talked to hundreds of people that have lost their job in the construction industry, even after years and years, and got nothing, or got a week or 2 weeks pay, and they realize, holy cow, I was owed 18 months pay. Yeah, and unfortunately 2 years have passed and they can't pursue it. Don't let that happen to you. If you lost your job, I don't care what industry you're in. Age, position, and length of employment is what factors into deciding how much you're owed. Go to severancepaycalculator.com, and if it tells you an amount, that amount is correct. There's no bug in the system. It's not it's not breaking. It's not breaking down. It's severancepaycalculator.com, and you can always call me as well to ask more questions.
And that number is 1-855-821-5900, or email help@employmenthour.com and employmenthourtv.ca. We're going to take a quick break and get back to the 10 commandments of termination of employment right here on Employment Hour in 30.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
Employment Hour in 30, right back at it here. 1-855-821-5900 or help@employmenthour.com. Discovering your workplace rights and then letting Lior Samfiru, employment lawyer, fight for them. And we're going to get right back to it here. The 10 commandments of termination of employment. We ran through the first 5 a number of minutes ago. Let's get to number 6, Lior. Thou shalt keep records of important events.
Very important. Sometimes you may have a situation, maybe you're being harassed, you're being mistreated, or maybe your compensation has changed, other terms of employment have changed. Dates are important. We want to know when certain things happen. So always keep track and keep records of events that have happened, the date when your compensation was changed, the date when your boss said something to you. We want to know when it happened. Sometimes that may be relevant to the issue of a limitation period. If there's a 2-year limitation period to pursue your rights, we want to know when something happened. I always say keep a diary, keep a journal, somewhere where you can write down important things that have happened, dates that have happened. And if you keep a contemporaneous journal, it gives you credibility. It's going to be very easy to prove the truth of what you're saying, rather than it being a he said, she said situation. So I'm a very, very, very big believer in documenting everything that's important.
Evidence, get evidence.
You have to, especially if you're getting that spidey sense that something is brewing there. Well, if they're keeping a record, they're keeping a file, keep your own file to protect yourself. Very important.
The 10 Commandments of Termination of Employment, number 7, and I'm going to add to this one here, Lior. Thou shalt not get advice from your neighbor Steve unless that advice comes from Lior Samfiru. How about that?
Yeah, unless I'm your neighbor and I change my name to Steve. But in all seriousness, the reason why I initially started doing a radio show many years ago was because I was on a message board reading about, I think it was golf.
Really?
And people were asking questions on that message board, just each other, about severance and losing their job and getting horrible, horrible advice. And I said, my gosh, if that's what people are doing, I gotta be able to give people the right information. So your neighbor Steve, your Uncle Bob, may love you and may want to do nothing but help you. But unless they're a trained employment lawyer, they're not qualified to advise you about your workplace rights. You can't do that, and you can't follow that advice, because guess what? Later you're going to find out that you've lost out, that it's too late to do anything about it. You're not going to go to your Uncle Steve and ask him about your serious medical condition.
No.
Well, then why would you go there for legal advice? You don't like me? That's okay. Speak with another employment lawyer. That's how important it is. But please get advice from the right source.
And you can talk to Lior, 1-855-821-5900, help@employmenthour.com, and don't forget to use severancepaycalculator.com. But getting back to the 10 Commandments of Termination of Employment, number 8, thou shalt assume that your severance offer is inadequate.
Well, I am not even going to talk a lot about that. That is the essence of what we're doing here. Severance offers are inadequate. 90%, over 90% of severance offers are completely inadequate. And if you know that and you realize that, you'll know you have to get advice. You'll know you have to go to severancepaycalculator.com. And if you don't, you will end up accepting an inadequate severance package. Severance packages are inadequate. You always have to assume that.
And this is a big one. Number 9 on the 10 Commandments of Termination of Employment, a big one. Thou shalt not sign.
Yes.
Thou shalt not sign.
And when we're talking about termination, we're talking about that severance letter. You cannot, should not, under any circumstances, sign that letter without getting advice. Now, there's going to be a deadline in there, and it's going to stress you out. You have to sign this by Friday at 5 or Monday at 3 or whatever it is, and you're going to want to do that. Don't do it. Resist that urge. Your legal rights do not expire Friday at 5. You have 2 years to pursue those rights. The problem with accepting the severance letter is once you've assigned it and accepted it, you're stuck. You can't get out of it, even if you felt the pressure and the duress. I can't get you out of it. I've gotten hundreds of calls for people in that situation. So you have a severance letter, take a deep breath, go home, have a drink to calm down if you need to. But go to severancepaycalculator.com, call me. Please don't sign until you do that.
We just discussed this, severancepaycalculator.com, but the last, number 10 on the 10 Commandments of Termination of Employment is thou shalt use the Severance Pay Calculator or call Lior Samfiru.
Well, there you go, bringing it back full circle.
There we go.
If you're confused about your workplace rights, call me. And when I say me, I'm talking about me, because I'm hoping by now you develop some comfort. But call someone that knows what they're doing. Go to severancepaycalculator.com. There's a lot of resources, good resources, accessible resources that are available to help you. So if you have workplace problems, understand that the law is on your side. Use that to your advantage. Call me. Don't suffer. Don't be worried. And always, always remember, I'm available to talk.
And I just want to go back to point number 9, thou shalt not sign. Many employers will use that as a pressure tactic. Right then and there, when they've just told you you're fired, by the way, you have to sign this in 2 days' time or the offer is gone. They're going to get you at your weakest moment.
That's it. And it's a horrible time anyway, because you lost your job. That's why by now, if you've watched this show, you'll understand how to deal with that. You won't feel that pressure or that stress. So that's why you can't sign. call me, I'll calm you down, and everything will be just fine.
The number to call Lior at is 1-855-821-5900, or you can email him help@employmenthour.com. And of course, you can always listen to us on the radio, The Employment Hour. And we'll do this again next week, The Employment Hour in 30. Thanks again, Lior Samfiru.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.